Hello everyone, welcome to StudyIQ English. I am your educator Praveen Mishra, and today we are going to discuss about the state Telangana along with the organization that is Supreme Court. So, what is the whole contrast here? What is the whole question or the whole news here? Basically, the Supreme Court, the Honorable Supreme Court of India, has actually bashed the Speaker of the Telangana Legislative Assembly on his delayed decision regarding the defection or disqualification of the sitting 10 member of legislative assemblies of the Telangana Assembly, basically. So what has happened? Simply, there are 10 MLAs coming from a party that is known as BRS. Those who have been considered as defected under the Anti Defection Law, that is under the 10th schedule of the Indian Constitution. But the fact here is still, the Speaker of the Legislative Assembly of Telangana has taken quite a long time in providing the absolute judgment, or basically the whole, what we say, simply the statement whether the sitting MPs or the sitting MLAs are to be defected or not. So here, the Telangana Assembly Speaker, once again, Supreme Court has asked this question, that why there is a delay. So basically what Supreme Court has called, the top court, sounded the warning bells. As you can see here, some warning bells as in type of order has been issued or an instruction has been issued by the Supreme Court, to the Telangana Assembly Speaker to decide the disqualification petition pending for several months. Around, it has been now 2.5+ months, against 10 Bharat Rashtra Samiti, that is in short BRS party MLAs. As you can see, not a small figure, right? 10 MLAs, right? Now, they shifted their allegiance towards the Congress party in the previous year, that is 2024, and right now, this should be taken into the consideration with the anti-defection, as you cannot switch your party allegiance as per the 10th schedule. What is 10th schedule? What are the constitutional provisions? We shall be discussing it in just next couple of minutes. So what Supreme Court has stated, what you need to mark here immediately, as per the statement given by the Honorable Chief Justice of India, Mr. B.R. Gavai, sir. So he has stated that all of the time when this disqualification proceedings are delayed, they become a natural death note. So after being kept in limbo by the Speaker for months, until the tenure of the assembly drew to an end, these are the things, nothing but these anti-defection proceedings, they become the natural death note in itself. So what they are considered? Simply naturally dead, right? This is what the Speaker must understand, that once a case has been given to you, you must act at the earliest possible time. And as per the recent judgment of the Supreme Court, recent as in the 2020 judgment of the Supreme Court, the Speaker must decide within 3 months, of the case whether an MP or an MLA is to be defected or not, right? Now, well, all of these things lead to the another term that is known as horse trading. What happens? One party lures another party's MPs or MLAs to come in favor of the other party. And this thing is particularly in India, not just in India, it is globally known as horse trading. When one party illegally, with some, advanced means of corruption, obviously in sarcasm, advanced means of corruption, when one party lures the incumbent MPs or MLAs, basically the legislators of another party, to favor in that another party, it is known as horse trading. And it has been, too much of a prevalent thing in India since 1960s. So let's talk about the origin of this phrase. So it started from this one particular person, Gayalal, who shifted his party 3 times in 9 hours. So it was the year 1967, as you can see, when in Haryana, an MLA named as Gayalal from the Faridabad district of Hodal constituency shifted his party 3 times in 9 hours. Right? So what happened? Gayalal changed his political party 3 times within a single day. First defecting from the Congress, then going to the United Front, then back to the Congress once again, and then finally going to the United Front again. So thrice in just 9 hours. Mathematically, once in 3 hours, Mr. Gayalal was changing his political party. And from there, you might have heard this very, wonderful saying we have got in Hindi, I Ram, Gai Ram. Someone who comes very quickly and someone who moves out very quickly as well, right? Vanishes in just split of seconds. So this is where the phrase we used, I Ram, Gai Ram. And so this I Ram, Gai Ram thing has been originated in 1967 through the Gayalal case, where he switched his parties thrice in single 9 hours, right? So what has been the consequences of this? In 1985, the Union Parliament legislated this one that is known as 52nd Constitutional Amendment Act and added the 10th schedule, that is the Anti Defection Law, in our Constitution. 101 and Article 191. So these two articles that deals with the anti-defection of the sitting MPs and MLAs. Right, everyone? So remember, what is the objective? To curb the political defections and bring stability in the legislative processes. Okay, so this is what exactly the case has been. Okay, that is known as defection. 52nd Constitutional Amendment Act, 1985. What has happened? Gayalal, okay, of 1967 case. We learned that, these legislators would be roaming like this. Horse trading would not end, and ultimately it will lead to too much of disturbances and turbulences in our legislative system. Hence, as a result, ultimately it will disturb the whole democratic process. So in order to curb all of these nuisances, okay, what Parliament came forward with? The 52nd Constitutional Amendment Act, that is known as the Anti Defection Law, that added the 10th schedule. So how a legislator can be defected? What are the grounds on which a legislator can be said defected? So the first one, if they voluntarily give up their party membership. Secondly, if they vote or abstain from voting against the party whip, that is against the party line, against the party instructions. Then if an independent MLA joins a political party after elections. So these could be the probable reasons on which grounds, on the grounds of whose anti-defection could be initiated against a sitting MP or MLA. So what are the things? Once again, if an MP or MLA, okay, sitting one, obviously incumbent one, who voluntarily gives up the membership of his or her political party, or simply if he or she violates the instructions given to him or her by the party whip, basically regarding the voting inside the assembly regarding any bill. And yes, if an independent MLA is there, the one who has no allegiance towards any party, joins any political party after 6 months of his or her elections inside the assembly, right? And finally, if a nominated member as well, okay, joins a political party after 6 months, right, into, there are nominated members we have got inside the Rajya Sabha. Though as of now, we do not have any provisions of nominated members inside Lok Sabha, but we have got in Rajya Sabha, right? Like, for example, we have got 12 members nominated by the Honorable President of India inside Rajya Sabha. Those who are experts in the field of, sports, literature, science, etc. So 12 members, those who are considered as nominated members. If they join a political party after 6 months of being nominated, then that is also considered as anti-defection, right? So now, role of the speaker in this. So speaker is the one who is considered as the deciding authority, as in the decision of the speaker would be final. But that doesn't mean, okay, it is immune from the judicial review. The speaker, okay, the decision, the judgment of the speaker will be subject to the judicial review, right? Now, there have been some issues with the role of speaker as well. As in, the speaker has been often criticized of being biased, because the speaker is usually from the ruling party, and the speaker may show absolute kind of biasness, that is, may delay or dismiss the petitions for political advantage. Further, this is exactly what Supreme Court is pulling up in the Telangana case, that Mr. Speaker of Telangana, why are you not taking some stringent actions against those 10 MLAs? So this is literally the sheer case of systematic biasness that we can experience, right? Next, the grounds of disqualification, as we have already discussed, right? Voluntarily giving up of the membership, voting against the party line, against the decisions or the instructions of the party whip. Independent MLAs disqualified if they join a political party after the elections, and then the nominated members if they join any political party after 6 months of their nominations. If they want to join any party, they can join within 6 months, but post 6 months, that is 180 days, they cannot, right? Exceptions. Do we have any kind of a split or merger? Yes, we have. Till the year 2003, if 1/3 of the members of one party, okay, they join another party, so it was considered as a split. But from 91st Constitutional Amendment Act, this split word has been changed to merger, right? And now the figures, they have been enhanced as well. Initially, through the 52nd Amendment, it was 1/3, but through the 91st Amendment, it is 2/3 of the members. So literally, okay, if 2/3 of the members, okay, they do join another political party, at least 2/3 of the members, if they join another political party, then it will be considered as a merger, and no MP or MLA would be prosecuted regarding the 10th schedule or the anti-defection law. But if it is less than 2/3, then all those MPs or MLAs, those who are switching their parties, they will be prosecuted through the anti-defection law. Right. So remember, guys, it was initially through the 91st, through the 52nd Amendment, it was 1/3 of the figures that was kept as a split, but it was enhanced to 2/3, okay, through the 91st Amendment Act of 2003. So initially the word was a split. Later on, this split word was changed to the merger. Right. Now, the Supreme Court's role and the landmark judgments. So what are the judgments that are related to the anti-defection law? So the first one is the most famous one as well. That is the Kilhoto-Holohan versus the Shilu in the year 1992, in which Supreme Court upheld the constitutionality of the 10th schedule and also stated that though the speaker's decision is final, but it is also subject to judicial review, right? But only once the decision has been made, not during the process of decision making, right? So that is what is actually democratic process. Then we have got the next case, Ravi S. Nayak case in the year 1994. So in here, Supreme Court held that voluntarily giving up of the membership doesn't need a formal resignation. Okay, if you are voluntarily resigning, it doesn't need a formal resignation, and just this conduct is enough to prosecute. And then we have got the third case, that is known as Nebam Rabia versus Deputy Speaker 2016. Here, it was Supreme Court's statement that the Speaker cannot adjudicate disqualifications if a motion for his removal is pending. Okay, if a Speaker is already, about to be removed, then there the Speaker cannot adjudicate any kind of a removal or any kind of a defection of a sitting MP or MLA. Then finally, we have got the most recent one, that is 2020 case known as Kaisham Meghchandra Singh versus Speaker Manipur. Okay, so what Supreme Court stated here, that 3 months, okay, simply Supreme Court stated that the Speaker must decide, that is, must provide the judgment within 3 months of the case. As in, for example, the Speaker got the case on 1st of January. So by maximum 31st of March, okay, that is by 90 days, okay, or whatever 90 days it would be, the Speaker must decide on the judgment. Okay, so this is what Supreme Court's statement or Supreme Court's order has come in the year 2020. What is the name of the case? Kaisham Meghchandra Singh versus Speaker of Manipur Assembly, right? So remember, guys, this 3-month concept, it is an instruction or the direction issued by the Supreme Court. It is nowhere mentioned in the 52nd or even the 91st Amendment Act. Okay, so these are the important cases and the things related to the anti-defection law. I hope everything is clear. If there is anything that is left to be discussed or you want me to discuss again, so please do let us know into the comment section. And apart from that, guys, please remember, if you are a serious UPSC CSE aspirant, so this information is for you. Our resolution batch that is commencing from 8th of August is specifically is for those students, those who are planning to appear in the examination of 2026. So what you will get once you enroll yourself into the resolution batch, 1,000+ hours of live classes, obviously, with access to recorded lecture, notes in the PDF format immediately at the end of the session, 18 sets of printed book given to you at your home, at your doorstep. You don't have to go anywhere to collect. 75+ tests for prelims test series, 15+ tests for your mains, that is the mains test series, as well as the interview guidance program. Everything will be covered under one single subscription that is known as the resolution batch for you. So guys, remember, if you're a serious UPSC CSE aspirant, this is for you, right? It will also include your mains residential program, as in simply, once you have qualified your prelims, that's for sure you are going to qualify. So you will be called to Delhi in Delhi's Rajendra Nagar, that is the hub of civil services, right? Here you will be staying in our accommodation. That is simply, you don't have to pay a single penny for your accommodation. Your accommodation will be totally on us, right? So once you have qualified your prelims, relax, your mains will be totally on us. Okay, you can come here, take the offline classes. Our great mentors and educators will be there. The teachers will be there to teach you, to train you, to prepare you for the next big exam, that is obviously the mains examination, right? And yes, one of the most beautiful things as well, once you have qualified your prelims, whatever amount you have paid for your subscription will be immediately refunded back to you. Okay, immediately this refund will be initiated without deducting, without just subtracting any single money, any single penny, whatever you have paid. So we have got multiple subscription plans for you. Like for example, we have got the gold, we have got the platinum, we have got the diamond subscription plans, and here the prices are starting with just rupees 9,999 only. And apart from that, you just need a promo code that is known as PRV Live. So guys, please use this promo code, okay, and get the maximum possible discount on any of the purchase of any of the course, right, on the StudyIQ platform. So guys, just keep this code copied with you, PRV Live. And remember, the next batches, they are about to commence from 8th of August. Okay, everyone. So thank you so much for joining, guys. Thank you so much for listening to me. If there are any questions, any doubts, please do let me know into the comment section. I'll be happy to help you. And in case you wish to connect with me, so here is the QR code for the Telegram channel that is named as Praveen_StudyIQ. Or else you can also connect with me on my Instagram account, that is Praveen_Mishra_2107. Right, everyone? So please, you can ping me here or even on the Telegram channel. And yes, please do not forget to hit the subscribe button of the StudyIQ IS English channel. You know it very well, channel dedicated and committed with only just one single agenda: to provide you all the quality and quantity of the content. Okay, everyone, so hit the subscribe button and never miss an update from the channel. Bye bye, good day, take care, Jai Hind, Jai Bharat.